Welcome, everybody. Good afternoon, and welcome to this Jobs Act webinar on benefit taxation, main terms and conditions of the recent Jobs Act Italian reform. Human capital. The first reason why foreign companies invest in Italy. The two main topics we will discuss today are the employment law and the reform of labor market. On those two topics, we have organized this webinar. It's co-organized by Invest in Lombardy and the law firm, the Luca Partners, specialized in the employment law. I am Marco Fedato, Global Development Manager of Invest in Lombardy. With us today, Vittorio De Luca, Managing Partner of the Luca Partners law firm. Let me briefly say a few words about why Lombardy, why invest in Italy and Lombardy in particular. If we, of course, consider the human capital as the main subject of our, one of the main subjects of our today webinar, what we can say about the human capital in Italy, in Lombardy region especially. First of all, let me just say a couple of words about Invest in Lombardy, special project within Promos Milan Chamber of Commerce, supported by Lombardy region and the Lombardy Chambers of Commerce, providing free of charge support to foreign companies that want to do business and finally investment in Lombardy and in Italy. A network of public subjects and private companies and professionals helping our team to support continuously companies from foreign countries that want to consider their business and investment in Lombardy region. We do this with the support, with the precious support of private partners. Law firm, the Luca Partners, is one of our strategic partners and helps us in dealing with foreign investors that want to do business and investment on Lombardy region. So please consider this webinar as an opportunity to, of course, better know important subject as it is the employment law and the reform of labor market, and consider the opportunity that Invest in Lombardy provides to foreign companies to lend in Lombardy, so which means discover the territory, the business environment, doing networking with the relevant subjects, companies, professional institutions on the field, in order to consider in a medium long-term perspective your investment in Italy. If we concentrate a little bit on the topics we will discuss today with the Lucan Partners today, let me just say a few words about how Lombardy as a getaway of investments in Italy can be your ultimate destination of investments in Italy, but not just in Italy, in Europe, as a huge market of potential 800 million consumers. So when we talk about Italy, we talk about a country which is still among the 10 most important industrial countries in the world. And if we think about Lombardy, we think about the ultimate hub in Italy for multinational companies, for foreign companies that want to do business in the country. So a regional GDP, which accounts for almost 1/4 of the national GDP, a number of companies that is more than 800,000 companies in all the fields, with a presence of almost 92% of multinational companies having their own headquarters in Lombardy region. A few words about why Lombardy can be the suitable destination of doing investment in Italy. Definitely innovation. a region which provides companies with a network of a tremendous network of researcher centers, universities, technology parks, which account for more than 30% of the national registered patents. When it comes to human capital, definitely a region which stresses a lot on the education and the strategic importance of the education in order to provide the business environment of potential high-skilled resources for the companies. So important universities worldwide recognized, and a network of educational institutions in all the sectors, from engineering to business, from design to architecture. This is why SMEs, especially SMEs in Italy and the Lombardy region, represent excellencies for foreign investors, more and more looking for investment. So SMEs which are capital seeking in order to boost their existing important presence in Italy and to find partners to invest abroad. When we analyze in details the high-skilled employees in Lombardy region, especially, we see that in terms of numbers of high-skilled employees, Lombardy is among the first country in region, in Europe, and this is an analysis which has been managed by the Financial Times through the FDI benchmark, and we see that Milan, if we compare huge cities and region in Europe, leading regions, of course, we see that the examples you see in the slides is related to the wood manufacturing sector, but this analysis has been processed in different sectors, so around 20 different sectors, and in 7 cases out of 10, so 70% of the survey show that Milan and Lombardy region is the first region to be considered if you take into consideration costs and quality. So very high quality of the high-skilled professional mixed with a very reasonable level of cost, something we will discuss together with Mr. De Luca later on today. A couple of final slides as for my presentation, specifically related to labor costs. So I introduce some arguments, some topics, so the 2 main topics of today's webinar, which will be more in detail addressed by Mr. De Luca, by showing you that labor costs in Italy, let's take a national perspective now because we will introduce the Italian Jobs Act reform. So we'll see that if we consider OECD and Istat data, we see that Italy, as of 2014, so as of last year, so before the introduction of the new Jobs Act, has lower hourly wages and lower labor cost compared to other leading European countries. You see in the slide the comparison is among France, Germany, Austria, and UK. And this showing the opportunity for companies of doing business and investment in Italy. Same thing related to the hours worked per worker. Once again, showing the attitude of the Italian workers, if it mixed with the reasonable cost that you see in the data, provide you even more reasons to consider investments in in Italy. Definitely, if you see this level of labor cost, which are related to the 2014 situation, this is definitely something showing that the new reform, which is now showing the first positive effects, will even more provide positive effects to the overall job market in Italy. In details, Mr. De Luca will show you this. Of course, we have to consider that the job market in Italy still struggles somehow, so the unemployment rate is still somehow a constraint, but definitely the recent reforms are definitely showing the positive effect, and we are confident that the trends will definitely help the country, especially if you consider single regions, as it's the case of Lombardy, where the unemployment is even lower than other averages in Europe. That's, at least for my side, is all for now. So I now leave the floor to Mr. De Luca for this specific presentation on the topics of employment law and reformable labor market. Thanks for being here with us today.
Thank you, Marco. I will now talk about the Jobs Act that has been mentioned a few times by Marco before. And first of all, I believe we have to say what we mean for Jobs Act. And the Jobs Act is the reform implemented in 2015 by the present government, which has been in charge by the Parliament to implement this wide reform. Our purpose today is to provide you with a brief outline of the main topics in the perspective of a company which intends to hire to hire people in Italy or to set up a business here. We will not mention all the areas that have been covered by the reform, which is very wide, as I said, but we will only concentrate then on the aspects that may be interested for people who intend to invest in our country. Actually, the main reason for the Jobs Act, so the 2015 labor law reform, is make companies more competitive in the global market. And this possibility to be more competitive is given through higher flexibility, allowing companies to more easily hire and dismiss employees in order to allow them to face temporary market changes that may derive from cyclical or structural changes. Aside with a wider and flexibility for dismissal of employees, the new reform has also introduced a specific reform of the active labor market politics in order to accelerate also through the intervention of public and private institutions to speed as much as possible the possibility for dismissed or unemployed people to be hired. The second pillar through which the government is intending to increase competitiveness of companies is made by simplification. I would say this is a key word of the new decrees, which are easy to understand. They are normally included in a consolidated text, So just to make an example, for temporary layoff regulations, we were used to have a number of law provisions, decrees, government decrees, ministry decrees, which made it not very easy for anyone to understand and access to it. Now, this is over. All the old rules have been cancelled, and all the rules for companies who intend to use temporary layoff procedures, which we call cassa integrazione, are all included in one single text. At the same time, when I say simplicity, I also refer to a reduction of accomplishments and, in general, bureaucracy. Bureaucracy is being managed also through informatization of any type of accomplishment that the companies are obliged to do. And this, of course, will drastically reduce any type of discretionarities by officers. Well, the reform in the 2015 reform is not the first reform that is being implemented in Italy. We are experiencing a continuous challenge by Parliament to reform the labor market and to reform the labor rules and the labor law. This because especially the present government, they are convinced that one of the key issues for companies is employment law. As I said, the reform is not yet over because a number of changes are going to be implemented in the future and are now under discussion. Just to give you an example, last Friday it has been approved a specific decree law concerning the right to strike. And the reform is not something which belongs only to 2014 and 2015, but we recently went through another deep reform of the labor law in 2012, which was called Riforma Fornero. So today we will go quickly through a number of items which may be of interest for you who are attending this webinar, but we don't have to forget that the premises for these changes have been really introduced in 2012. With the Fornero reform, as I said, sorry, I'm trying to get the slide. Okay, no, don't have it anymore, sorry, but I will explain it to you. The Fornero reform was mainly on regarded mainly four aspects. And the four aspects are reform of the protection of employees in the case of unfair dismissal. And from this point of view, already in 2012, the area in which reinstatement of employees unfairly dismissed has been drastically reduced. The second area is speeding the judicial proceedings in order to make to allow judges to reach decisions in the shortest time. Based on this reform, now when an employee sues a company for unfair dismissal, he can get to a decision within 3 or 4 months. Then in 2012 has been introduced another reform concerning the introduction of an alternative dispute resolution, according to which employers who intend to dismiss people for economic reasons or for a reorganization of the company must necessarily make a previous attempt of settlement with the employee in front of a public office. And I have to say that this procedure has already substantially reduced the number of judiciary proceedings. And the fourth point of the reform in 2012 concerned the pension system, which is now in complete balance due to this reform. Today we will discuss only, as I said, only a few subjects. And the first one is subsidies. Subsidies for new hires. So the government decided to start with I call it a shock to the labor market by introducing a very strong subsidy for employers who intend to hire employees who do not have a steady job. So this is the main purpose of this new subsidy. The subsidy allows companies not to pay Social Security contributions up to 8,000 euros per year for employees hired in 2015, and the duration of this subsidy is for 3 years. So an employee without an indeterminate time contract who is being hired with an indeterminate time contract in 2015 will allow the employer not to pay Social Security contributions up to 8,000 euros, 8,060 euros per year of Social Security contributions. This involves for a company the consequence that we have estimated up to 26,000 euros compensation salary for the employee. There are no charges at all. And I will show you now a slide concerning the estimation for a case of 50,000 euros, which you can see now. And in this case, the company cost, rather than 64.5 thousand euros, amounts to 56,400. But we also have to say that the reduction in Social Security contributions introduced in 2015 is not the only subsidy granted to employers who hire staff, but there's a number of them. I will just, some of them are mentioned in the slide you can see now, and as you can see, there are cases where there is a substantial reduction of Social Securities, like in the case of employment of people who've been previously dismissed. And in this case, the employer may benefit of a reduction to 11% Social Security contributions for up to 18 months, and a direct subsidy to the employer of the unemployment indemnity allowance which was due to the employee until the end of the period. There are also reduced Social Security contributions for employees who are hired through an apprenticeship contract, and there are subsidies for young people hired when they are younger than 29 years old. The second area that I will briefly describe to you today is short-term contract. It's customary in Europe that a company may enter into a short-term contract of employment with an employee only provided that there are specific reasons. This was customary in Italy as well, and until not long ago, it was possible to enter into a short-term contract but only in the presence of specific reasons to be mentioned in the employment contract. These reasons were normally brought to the attention, or often brought to the attention, of lawyers and judges, and were a reason for litigation. Now, the government, as in 2014, it was the first step of the reform of the present government, has cancelled, has completely deregulated the short-term contract by introducing the possibility to hire anyone with a short-term contract for contracts overall up to 36 months, and with the possibility to make up to 5 extensions. This means that an employer may now hire an employee for a 6 months contract and then make extensions up to 5 times, but overall not transpass 36 months overall, as I said. The only limitation is that short-term employees must not exceed 20% of the staff employed by that employer, and the national collective agreements may provide for different rules, so even higher or lower percentages. We have to add that only if the limits of 36 months and 5 extensions are exceeded, then the employment relationship becomes indeterminate time contract. But in no other case this may happen, and it doesn't happen definitely in the case the employer exceeds the 20% limit. The second item I would like to address to you today is simplified code of conduct. That is merely an example of what I mentioned to you about the intention of the 2015 reform to simplify the code, the employment law, to reduce discretionarity of anyone who is involved, and therefore the number of contracts with which employees may be hired have been reduced. The main type of employment contract which has been defined by the reform is the indeterminate time contract, and for this reason the new lawmaker has decided to introduce the type of protections in the case, the type of flexible protection in the case of unfair dismissal that I will describe to you today. The purpose of this intent to simplify is then to strengthen the opportunities to enter the labor market for people who are not in, and to simplify in order to reduce uncertainty. In this context, we will now talk about the freelance contracts, which have been in our country used in the past quite often as a way to escape from the strict rules provided by law for the case of unfair dismissal. The government, by having introduced this new type of protection, flexible protection in the case of dismissal, has at the same time substantially reduced the number of cases where freelancers may be hired. And just to let you understand what we're talking about, basically it will not be possible now to use freelance contract to hire an employee who is actually performing activities as an employee. And to allow this process to be faster and to help companies going through this process of change, the government has also introduced a tax amnesty for employers who transform freelance contracts from freelance contracts into indeterminate time contracts. So, if this happens within the end of 2015, the employer will benefit of a tax amnesty. So, the authorities will not be in a position to require payment of differences in social securities for the past. And at the same time, the employee will be hired with the new type of contract with predetermined allowance due in the case of unfair dismissal. That, as I said, I will describe to you at the end of my speech today. The intent of the lawmaker to reduce bureaucracy and to simplify the labor law is also clear in the apprenticeship contracts, where the procedure has been simplified, and a number of additional cases where apprenticeship can be used have been introduced, and the exemption, partial exemption from Social Securities has been prolonged for 1 year after the end of apprenticeship. Next subject I believe is interesting for you to be aware of is legitimacy of downgrading. Until the reform entered into force, it was provided by law that in no case the employee could be downgraded. I have to say that case law already introduced the possibility and allowed the possibility to downgrade, notwithstanding quite clear laws saying that this was in general not possible. But case law has in recent years allowed the possibility to downgrade in all cases where downgrading was useful to prevent dismissals. So now this case has been clearly stated in the law and provided as a possibility. Therefore, after the reform of the 2015 reform, the employer is entitled to downgrade an employee in the case of a reorganization. So there is no need to prevent the employee from being dismissed. But in any case of reorganization, the employee may be downgraded to the one level lower than the one to which he is enrolled. And this can be done unilaterally, which means that there is no need of an agreement with the employee, but the employer is only obliged to notify the decision in writing to the employee. However, in this case, the employer is obliged to provide training if necessary for the new duties, and may not reduce salary and formal level of enrollment. Furthermore, the new provision allows employers to reduce not only the level, not only the duties to which the employee is assigned, but also the formal level of assignment and the salary of the employee when an agreement is reached with the employee. So, with an agreement, the employer may reduce may assign the employee not only to the lower duties, but also reduce salary. This may not be done in any case, but I would say that the cases provided by law are quite wide. And so it's difficult to imagine when it will not be possible for the employer to reach this type of agreement with the employee. And the cases are dismissal prevention. So, as you remember what I told you before about the case law provision. And also when the downgrading is aimed at allowing the employee to acquire different professionality. and or to improve his quality of life. So, for instance, in the case of an employee who needs to work part-time and not full-time anymore, but the part-time does not allow the employee to continue to perform the previous duties, so in this case, the change will definitely be possible. The next argument I would like to describe to you is distance control. This was another key point of strict labor law in the past. So, in general, for the protection of the person and the privacy of the employee, the employer was not allowed to assign to the employee or any way to use instruments allowing him to perform distance control on his work activity. Now the rule has been changed. So, I'm sorry, it was not possible unless the use of these tools was governed by a trade union agreement and by a specific authorization from the labor authorities. Now this rule remains, but any tool and any instrument which is assigned to the employee to perform his duties does not require any specific trade union agreement or any authorization from the government, from the labor inspectors. The only obligation for the employer is to inform the employee of the information which will or may be collected and the potential use that may be done with the information collected. So, for instance, the control of the specific activity performed by the employee will be possibly used also in a grievance procedure determining then the dismissal of the employee who has not been performing correctly. Of course, in any case, the information collected and the instruments assigned to the employee must be compliant, fully compliant with the privacy law, with the data protection law. The final subject I would like to describe to you is the reform of dismissals. As I said to you, the reform actually started in 2012, where the cases of reinstatement of employees unfairly dismissed has been reduced. And now, with the 2015 reform, it has been the reinstatement possibility of employees unfairly dismissed has been reduced basically to the cases of discrimination, or to the cases where it is proven within the trial that the facts objected to the employee, or that the reasons mentioned in the letter of dismissal do not exist. So basically, it will be up to the employee to demonstrate that discrimination acts have been accomplished by the employer, or that the reasons mentioned in the letter of dismissal do not exist. And the new law also provides that the judge will not be entitled to enter in an evaluation whereas the reasons exist but they're not sufficient. So the law simply states that the judge has to verify whether the reasons exist, and if they do, the only consequence that may derive from the dismissal is that it is declared unfair because, I don't know, the reason mentioned is not in the for the judge is not considered as sufficient to justify the dismissal, but in this case, the only consequence will be economic consequence. And not only economic, but also predetermined. So the 2015 reform intervened in the main weak areas of the previous system of protection for unfair dismissal, which was the difficulty to make a provision to forecast the cost of a dismissal due to reinstatement, which of course cannot be, does not allow the employer to make an estimation of cost. Of course, I don't want to say that all or the number of cases of reinstatement is significant. I have to say that in the last 20 years, the cases of reinstatement have really been rare and exceptional. But making an assessment in advance about the possible consequences of a dismissal, it was difficult to make an estimation. So now the 2015 reform, which applies to any employee who has been hired as of March 7, 2015, allows to make a specific forecast of the cost, because if the judge considers unfair the dismissal, then the indemnity which is due to the employee is predetermined by law with a very simple algorithm, which is 2 months' salary per each year of seniority, up to maximum of 24 months. So depending on the seniority of the employee, it is easy and easy to make an estimation of the possible cost. If you can, of course, exclude that dismissal may be proved to have been determined by discrimination, so a reason concerning sex, religion of the employee, and if you can be sure that the facts which are at the basis, due to which the employee has been dismissed, will be easily proved in court. Another characteristic of the reform 2015 concerning dismissal, unfair dismissal, is the alternative, the ADR procedure, the alternative dispute resolution procedure, which has been introduced by the 2015 reform. According to this reform, the employer, within 60 days from the dismissal, is entitled to offer to the employee 1 month's salary rather than 2 that I described to you before, for each year of seniority. So this means that an employee having 6 years seniority within the company may be offered 6 months salary rather than 12. And in this case, if the employee accepts the offer, the economic amount will be exempt from taxes. So this makes for the employee really not opportune to enter into a judicial litigation, because in the best case scenario he would be entitled, in the example I just made, to 12 months salary but subject to tax, which makes the gain, if compared to the case he accepts, the 6 months net salary, 6 months salary net of taxes, it gives a spread which is very little, and probably it will not make it convenient for the employee to run the risk that the judge declares the dismissal fair, and in this case the employee wouldn't be entitled to any allowance. This is why we believe that in the next few years, as the new reform will involve a substantial number of employees, the number of judiciary litigations for unfair dismissal will be reduced dramatically, and I expect almost to nil. And the only cases that will be brought to the attention of judges will be those concerning discrimination, which is a specific purpose of the judge, so of the reform, 2015 reform. So those cases that have to be brought to the attention of the judge must be those who really deserve to be regarded by the judge in a judiciary litigation. What I just referred to concern employers concerns companies having more than 15 employees, whereas in the case of employers having less than 15 employees, the maximum indemnity, rather than 24 months, is 6 months. So the employee, depending on seniority, may be entitled, in the case of unfair dismissal, which is not due to discrimination, may be entitled to maximum 6 months salary, depending on seniority. In the chart you can see now, we have tried to describe the flow of what happens in the case the settlement procedure fails, which, as I told you, will be unlikely in the next few years. So in this case, the employee may bring the case in front of a judge, and the judge may decide whether the dismissal is lawful, and in this case only the notice period is due to the employee, or unlawful. But in this case, only the predetermined allowance, depending on seniority, will be granted to the employee. I would like to conclude my speech today with the reference to the survey we are carrying on together and in partnership with Invest in Lombardy. We would be pleased if you can participate to our survey, and our survey concerns the impact on Job Act, and you will find some questions, and also you will have the opportunity to make suggestions on what, if and what is still missing in the Italian labor market, if anything is. So if you want to participate to our survey, you can, you should be able to see on the right of your screen a button called survey. I'm asking confirmation if I remember correctly. Yeah. Okay. And it will take no more than 10 minutes to reply to the 14 questions of the survey. Main are yes or no or predetermined answer. But you will also find a number of blank spaces where proposals can be carried on. And the result of this survey will be discussed in the Invest in Lombardy days on October 15 here in Milan, together with Employers Association, union representatives, and Ministry of Labor representative, and HR managers of important Italian companies, to share the results of this survey, and if possible, even to present a proposal of additional steps of the reform of the Italian labor law. Today, this is all for me, but today we would like to end the webinar with two more things. One is to ask you to reply to 4 brief questions. You should see on your screen now the first of them. And then, immediately after we will have finished, we are here to reply to any further question you may have. So I will now describe the 4 questions that we are asking you. And so the first one is whether you believe that the Jobs Act reform that I briefly described to you consists in a substantial progress in the Italian labor law. So if you can vote immediately after we will have collected your opinions, we will share with you immediately the results. Okay? Okay. I will show you now the result. Sorry. Now you should be able to see the result. So apparently there's someone who believes this is not sufficient. It would be interesting to know what is missing, but maybe the answer to my question may, yeah, it's okay. The answer to my question may come by answering to the next questions you will find on the screen right now. First one. Do you believe that there are specific additional reforms or changes in the Italian labor law, and in particular reduction of tax wedge, reduction of labor costs, reduction of bureaucracy, reduction of length of trials, and application of progressive entitlement, what I call predetermined allowance in the case of unfair dismissal? Please answer. Okay. Okay, these are the results. Okay. I believe this is self-explaining, but also gives me the opportunity to say that one specific task of the government, which has not been accomplished yet, is reduction of cost of indeterminate time contracts. So the Parliament has addressed, has in charge the government to issue a specific regulation making the indeterminate time contract the most convenient, the most economic type of contract in the labor market. Because this is the specific purpose of the reform. It is to try to make it not convenient to employers to go through contracts which are different than the indeterminate time contract. And for this reason, the indeterminate time contract has been made much more flexible, and the cost of exit, as I told you, easily predetermined. So next question is if you believe that there are issues that may prevent investments or hiring in Italy. So let's see I will give you a few seconds to reply before I show you the result. Okay. Okay. Apparently, main issue is considered to be the labor cost. Okay. And final question. What you consider the main three measures introduced by the 2015 reform that may be crucial in encouraging hiring and investments in Italy as far as labor law is concerned, of course? Again, I will wait just for a few seconds before showing the result of this online survey. Okay. Apparently, downgrading provision reform is absolutely sufficient, and exemption from Social Security contribution is the winning and the most crucial within the 2015 reform. Okay, I think this is all from my side. I don't know, Marco, if you want to add something. There's one question concerning the possibility. We've been asked, what about the temporary agency work, so-called somministrazione? Any news about? Actually, I did not mention, but the deregulation that has been implemented for indeterminate time, for determined time, fixed term contracts, also applies to staff leasings. So the possibility to hire temporary work through a labor, a work agency. So up to until a few months ago, before the reform entered into force, there were still cases where a specific reason had to be mentioned to enter into a staff leasing agreement, which is now not necessary anymore. So unless there's any other question, I believe we can conclude.
We'll just add one thing about the contents of this webinar. So all the content will be available also after today. So on all Invest in Lombardy social, so on YouTube channel, LinkedIn, and Invest in Lombardy blog. So all this information, precious information that we have shared with Vittorio De Luca will be available for the people interested. And we will, of course, share with all the people interested, with all the participants of the today webinar, all the results of the survey. And we will definitely be glad to invite all the people interested to our upcoming events, as mentioned by Vittorio, during the Invest in Lombardy days will take place October 12th to October 22nd. So thanks, Vittorio, for helping today with this very interesting and important topic. And we'll soon keep in touch with all the participants for upcoming events and occasion of exchange of information about investing in Italy and in Lombardy. So thank you. Thank you, Vittorio.
Thank you very much. Bye.